Good morning, everyone. Welcome to the regularly scheduled meeting of the Board of Public Works for today, Friday, April 5th, 2019.
Commissioner Garcia, Cabello, James, and Caloza are present. President James, we do have a quorum. May we start with Bureau introductions, please, starting with Bureau of Street Services.
Good morning, Chiman Gong for the Bureau of Street Services.
Good morning, Neil Drucker, Bureau of Engineering.
Good morning, Angelica Samayoa with the Bureau of Contract Administration.
Good morning, Efrain Gonzalez, Bureau of Sanitation.
Good morning, Asad Al-Najjar, Bureau of Street Lighting.
A City Attorney's Office.
Fernando Campos, Executive Officer. President James, we do not have any speaker cards under general public comment. We also do not have any commentary under the Neighborhood Council comment section. We did receive a speaker card on item number 5 for today's agenda.
Okay, thank you. Then we'll close general public comment as well as the Neighborhood Council category of commentary. Agenda item number 8 is a stop payment notice from Robertson's. They've transmitted that in the amount of $6,488.37 for furnishing ready-mix concrete, rock, and sand materials in connection with the First Street Viaduct over Glendale Boulevard project. The primary contractor for the project is Steve P. Rados Incorporated. Is there a second to my motion that we receive agenda item number 8 forthwith by Commissioners Cabello and Garcia? Any objection? With that objection, we will do so. Agenda item number 7, specifications submitted for board adoption and authorization to advertise for the invitation of bids pretty much all over the city. This is 1, 2, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, and 15. I think it's everyone but 3. For the Vision Zero Phase 2B Metro Blue Line improvements and highway, rail grade crossing improvements, and I-5 corridor transportation improvements. The estimate is $6,998,331. The bid receipt date is May 8th, 2019. Is there a second to my motion that we approve agenda item number 7 forthwith? By Commissioner Caloza. Any objection? With that objection, we will do so. Let's go to number 6, our final administrative item. The Mayor and City Council has approved and authorized the Board on behalf of the Bureau of Engineering to execute amendment number 2 to 9 contracts for pre-qualified on-call civil engineering consulting services for the Street Improvement Program for an additional 3 years, from March 17th, 2019 through March 17th, 2022. A total on that is 13 years, upon verification that the consultants are in compliance with the insurance and contracting requirements. That will be a fun evening for me signing all those contracts. Is there a second to my motion that we approve agenda item number 6 forthwith by Commissioner Garcia? Any objection? With that objection, we will do so. Let's go ahead and take agenda item number 2, hearing on ordinance number 184977 and 184972, transfer approval. Oh, I'm sorry. Oh, okay, we have a presentation today. Oh, it's written here, but I didn't see it, so thank you. We have a Women's Heritage Month presentation, so Commissioners Caloza, Garcia, and Cabello. This is, one that was remaining after last week. Okay. That might have been what threw me as well. It's okay. Commissioner Caloza.
Thank you, President James, Bureau representatives, and colleagues. Good morning. We would like to officially designate April 2 as Women's History Month. No, I'm just kidding. But no, all jokes aside, we have one person, one female, one woman from the Bureau of Engineering who wasn't able to be here last week. We wanted to make sure that we honored her in the leadership at the Bureau of Engineering and also all these women in these non-traditional roles to really make sure that we give time and attention to them, even though it's no longer March, right? We should be honoring them every day, every month, in my opinion. But I'd like to bring up Natalie. Moore from the Bureau of Engineering. You can please come up here. So Natalie Moore is a civil engineering associate for the Bureau of Engineering, where she plays a vital role on the project and construction and management team for the 6th Street Viaduct Division. She began her career with the Bureau in 2006 as a student engineer in wastewater conveyance, working in the air treatment facility program. She's held a number of positions in the divisions before jumping at the exciting opportunity to work on the 6th Street Viaduct. She's managed a number of projects, including the implementation of a dispute review board for the viaduct project, which was not previously a Bureau of Engineering project. And she worked a lot with the city attorney's office to modify the language and really make sure that she stays on top of this project that is going to be, from what I understand it, the most expensive bridge in the city's history. And so, you know, no, in terms of investments, and should I rephrase that properly? Clarify that. The biggest of the city's investment in terms of bridges, but and infrastructure. Thank you. But you know, it shows how much time and attention that Natalie has put into this project, and really making sure that our infrastructure projects are up and running. So congratulations, Natalie. With that, on behalf of the Board of Public Works, we'd like to present you a certificate of recognition for all your work. Happy belated Women's History Month.
Thank you so much.
You want to say a few words?
Oh, thank you so much to the Board of Public Works for this recognition. Like Commissioner Caloza had mentioned, I'm very fortunate to have the opportunity to work on the 6th Street Viaduct Replacement Project for nearly the past 3 years now, and it's really more exciting to be honored for this. As you know, our team is led by a number of women, especially Julie Allen, and so I take a lot of pride in working alongside her and Julia Moy and the rest of the team, and getting to have this opportunity to empower women, especially working in construction management, which is very untraditional role. So thank you so much for this recognition. I really appreciate it, and thank you.
Thank you, Ms. Moore. I was wondering whether I should say something. We're honoring you today, obviously, but you took the words out of my mouth, too, by mentioning the leadership at engineering on this project, not just yourself, but Ms. Allen and Ms. Moyne as well. And it is a legacy project, not just for the city, but for the region. That speaks to your stellar career with the city of Los Angeles, and thank you for being a leader, not just of engineers in the city and those that work with the city, but as was mentioned by Commissioner Caloza, and we've mentioned before as well, for women and girls all around the country, really. I always steal the line from Councilwoman Martinez, but I do provide credit. You know, she always says you can't be what you can't see, and that's just true. I always, and now I'm going on longer than I had intended to, but I've been to a couple of conferences recently, and I've said this before too. You know, when the city of Los Angeles visits a national conference, it is very clear that Los Angeles is leading the nation in two fronts. One, with women in leadership, and two, with inclusion and diversity in leadership. And those two things go hand in hand, obviously. But it's very clear. We see that really everywhere we go. While I'm proud of that, I'm also a bit embarrassed of it for the rest of our country. So, but somebody's got to be up front and be the leader, right? And it best be us. Thank you and congratulations. Commissioner Davis.
Good. I'd like to thank our commissioners here on the Board of Public Works, Caloza, Cabello, and Garcia, for their outstanding work in recognizing the women in the city of Los Angeles. And Natalie, specifically to you, congratulations. When we initially this month recognized women, I pointed out that this city is a welcoming place for women, and the mayor has led the way in terms of making sure that of his appointees, that over 50% of those commissioners are women, because we want to make sure that women are welcome. And I always talk about our city that we serve, where we do have a lot of families that are headed by women. And so for that reason, we care very much about making sure that there is inclusion, not only in diversity across the board, but specifically among women. You are an example of being a person who is working on the 6th Street Viaduct Replacement Project, and you're in a profession of engineers where I am very, very aware that the majority of the people that work in engineering are men. So we welcome, and I'm so glad that you have been chosen to be recognized, because we want to see more women engineers as well. So you're a great example, and every day, our commissioners are right, every day is Women History Day in the city of Los Angeles. Congratulations.
Thank you.
I always like to say, especially for us when there's 3 of them on the board. Our city engineer is here, and Julie Allen as well. Gary, if you want to come on up. We'll take, Gary, do you want to say something? I thought you might.
No, I just wanted to say, when Natalie commands the room, and when she says something, we're in a meeting, with Julie and herself, sometimes the only women in the meeting, and the contractor, we may have women running but they are like 100% male. And then we have the disputes review board, 100% male. But when they need facts and they need the right answer, who do they turn to? Natalie. It's awesome. It's awesome to watch Natalie's depth and knowledge, and don't challenge it. And I've seen other people try to challenge it. I just sit back and watch. Natalie just comes back with the utmost respect to the question, but the depth of the answer is just a leader and an example for the entire Bureau of Engineering for her preparedness, and I'm honored to work with Natalie. And Natalie, congratulations from all your friends in the Bureau of Engineering. Thank you.
Great. Thank you for coming, Gary. So we'll take just a moment of our agenda, a moment recess for a photo. We'll be right back. Okay, thank you, everyone. Returning to our agenda. Oh, there we go. Thank you, Commissioners Cabello and Caloza and Garcia. Let's take care of agenda item number 2 now. And Mr. Intuck, 2 and 3 don't have anything directly to do with each other, correct? Okay. Agenda item number 2, hearing on ordinance numbers 184977 and 184972, transfer approval of pipeline franchise assets, recommending that the board approve the transfer of certain pipeline franchise assets from SFPPLP, ordinance number 184977, to Phillips 66 Company, ordinance number 184972. We've seen 1 or 2 of these recently. Mr. Intuck on agenda item number 2.
Good morning, President James, boards members, leaders of Public Works Department. This is a longstanding item that we're resolving related to the transfer of pipelines from the Department of Transportation in 2017, or the function of the pipeline franchise agreements in 2017 to the Board of Public Works. This was a transaction that occurred where two existing pipeline franchisees sold a portion of the pipeline to another company from SFPP, which is really Kinder Morgan, sold pipelines to Phillips 66. At the time was called ConocoPhillips. Have since changed their name, but the same company. Payments have been made for this portion of pipeline for the city over the period. This transaction happened in 2004, but we've just never officially recognized it and amended the franchises. Both franchisees are compliant with bond insurance levels and payments, and this is going to have no fiscal impact. It just is basically making sure that we're accounting for the pipeline inventory appropriately.
Great, thank you. Any questions? No questions. I'll make a motion that we adopt agenda item number 2, seconded by Commissioner Davis. Any objection? Without objection, we'll adopt agenda item number 2. Any issue sending number 2 forthwith? We will send number 2 forthwith. Is there a second to my motion that we approve the meeting minutes from the meeting of Wednesday, February 27th, 2019 by Commissioner Cabello? Any objection? Without objection, we will do so. Agenda item number 1, contract amendment, Council District 15 sidewalk construction and public right-of-way infrastructure improvements, recommending that the board authorize the Office of Community Beautification to execute a contract amendment with the Los Angeles Conservation Corps in the amount of $300,000 to provide funding for sidewalk construction and public right-of-way infrastructure improvements in CD15 as funded by Council File 12-0546S1, and secondly, authorize myself or 2 members of the Board of Public Works to sign the contract amendment after approval as to form has been obtained by the city attorney. Mr. Roch on number 1.
Good morning, Paul Roch, Director of the Office of Community Beautification. As everyone is aware, the Los Angeles Conservation Corps is one of the nonprofit community-based organizations under contract with Office of Community Beautification. Among the various services that LACC performs, this includes sidewalk repair and related services to sidewalk repair, such as concrete repair and removal, street tree replacement, repair, removal, and replacement of access ramps, curb and gutter repair, driveway apron repair, removal, and installation, and many other as-needed services. The Office of Councilmember Joe Buscaino has provided supplemental funding in the amount of $300,000 for these services to be provided by the LA Conservation Corps in Council District 15. Funding has been transferred from the CD15 pipeline franchise revenue account into the Board of Public Works contractual services account. In addition to providing these valuable services in the district, it will also provide several jobs, job skills, job training, and job experience to several at-risk youth or young adults. They won't be using youth on these projects, but young adults who are residents of the city of Los Angeles. We are now this morning requesting board approval to amend an existing contract with the Conservation Corps in order to provide the funds for these services. Thank you for your attention to this item.
Great, thank you. Paul, any questions? Commissioner Davis.
Paul, I wanted to ask in terms of our outreach to get the young people, young adults, to get involved in interviewing for jobs. How does that take place? Is it done council district by council district, or does the Conservation Corps go out to do outreach throughout the city? How does that happen?
Well, a combination of both, really. I mean, the Conservation Corps does do outreach, and there are also a number of people that just, get referred to the Conservation Corps. But then when they have projects specific to a council district, such as this, then they will work also with the council office to try to find at least some of the people, who are residents of CD15 to participate in this. This is a little bit more of a, technical type of job, so it's not necessarily something that, just anybody would be able to kind of pick up, as would the weed abatement or litter cleanup or something like that. But.
Okay, thank you.
Thank you, Commissioner Davis. Commissioner Capel?
Couldn't help myself. Thank you, President James. I want to commend Councilmember Buscaino and CD 15, Council District 15, for putting their own skin in the game on this, but using their own money to make sure that vital infrastructure is done, not only to improve the city, but also to help train young children, or young adults, not children, we abide by all laws, but making sure that folks who really need those job skills are getting those as well. So just, even though they're not here, kudos to CD 15.
Thank you. Anything further? Was that a motion, Commissioner Cabello? Seconded by Commissioner Davis and Commissioner Garcia. Any objection? Without objection, we'll adopt agenda item number 1. Thank you, sir.
Thank you.
Any issue sending number 1 forthwith? We'll send number 1 forthwith. Agenda item number 3, hearing on ordinance number 184966, termination of NASCO Petroleum LLC pipeline franchise. First, find that ordinance number 184966 related to NASCO Petroleum LLC for operations of pipeline vault assets below the city streets expired by its own terms on March 16th, 2019. That's transmittal number 1. Secondly, concur with the automatic termination of NASCO's ordinance number 184966. 3, order NASCO to cease use of all franchise assets immediately upon action by the board, recognizing the termination of ordinance number 184966. Number 4, order NASCO to submit a pipeline abandonment plan for approval to the Petroleum Administrator within 30 calendar days in compliance with Section 4.7 of Ordinance 184966. Are you guys here from NASCO? So I didn't have any speaker cards from you. Go ahead and turn those in and let me call another item. Okay, thank you. I thought you guys were here from another item. Let's go to agenda item number 4, Council District 11, change order number 38. Dr. Campos, do they have cards to fill out?
They do. They're filling them out.
Okay. Change order number 38, Vadnais Trenchless Services Incorporated, recommending that the board authorize the city engineer to issue a change order to VTS for a not-to-exceed amount of $1,800,000 for the Venice Dual Force Main and Venice Pumping Plant Generator Replacement Project to purchase the reinforced concrete jacking pipe for the redesigned 1,800 linear feet of tunnel from shaft number 1 to the Waterview diversion structure. Mr. Ryan, how are you? Mr. Tolles.
Good morning. My name is Ryan Tolles from the Bureau of Engineering, Wastewater Conveyance Construction Division. I'm here today to request authorization to continue with a $1.8 million change order in connection with the Venice Dual Force Main project. This is a combined project with the Venice Pumping Plant Generator Replacement. On January 18th, 2017, the Board of Public Works awarded a contract to VTS in the amount of approximately $88 million with a contingency of about $4.4 million. The total construction budget is $93 million. This change order is related to the Venice Dual Force Main portion of the contract, which is to construct a 54-inch diameter force main that extends approximately 10,400 linear feet. It starts at the Venice Pumping Plant at Hurricane Street in the community of Venice, and it crosses the Grand Canal beneath Marina del Rey and Bayona channels, and then it travels southerly along Pacific Avenue and Vista del Mar, where it terminates near Waterview Street. This change order will modify the installation method of the south end of the force main. This modification deletes approximately 900 feet of open cut and converts that to a micro-tunneling installation method instead. This change is heavily supported by Council District Office 11 in an effort to reduce traffic impacts in the Playa del Rey area and along Vista del Mar Street. The change also reduces the construction activity by approximately 5 months. The original installation method would change the traffic configuration on Vista del Mar from 2 lanes in each direction to 1 lane in each direction. So we would go from a 4-lane situation to a 2-lane situation. With this modification, we are able to accommodate 2 lanes in one direction and 1 lane in another direction. So we end up going from 4 total lanes to 3 total lanes. The selected micro-tunneling method is called a 2-pass method, which requires a jacking pipe to be installed, which is then followed by a smaller sewer pipe. The concrete jacking pipe has a lead time of approximately 4 to 6 months, so ordering the jacking pipe to prevent project delays was important for the project. So BOE obtained emergency authorization from the BOE Liaison Commissioner for a not-to-exceed amount of $1.8 million in order to proceed with that pipe procurement. After approval, we directed the contractor to proceed on January 31st of 2019. And there's a forthcoming change order and board report that will, once the complete change is negotiated. So the purpose of doing this first was to avoid delays on the project. And so right now, the total change is estimated at approximately $6.6 million. This 1.8 is part of that 6.6. I'm requesting concurrence and authorization to continue with the change, as well as I'm here to answer any questions associated with it.
Thank you, Ryan. Commissioner Davis?
I see that we are making some progress in resolving challenges that have occurred on this project and obviously coming up with some appropriate solutions to move forward. But as I look at this project, $93 million, I am questioning in terms of our capacity to involve as many people as we can in it. And I know you have to be certified to do this work and it's highly specialized. But having said that, could you tell me, or do you happen to know, do we have any local hires on this project?
I don't have those statistics with me, but I can get the statistics of, we do have requirements in the contract.
Sure.
And so where the numbers are today, I can get that information and report it back.
Please do. The other thing is project labor agreement. Is this one of the projects in which we've implemented a project labor agreement?
I believe it is, but I'm not certain.
Okay, please
So
get that back
I
to
can
me.
confirm
Whenever
on
we
this.
have these kind of dollars going out into communities, we have to capture those, I believe, as best we can to do what we can to help augment some of the potential people who could be working on it and make sure that they are part of helping to make sure that this project is all that it can be, not only in terms of quality of the construction, but also in terms of inclusiveness of what the dollars could do in certain communities. So I appreciate that.
Thank you. Anything further? I hesitate to ask. What percentage is this complete?
Right now, the tunneling is approximately 40% complete.
Okay. Not a large number yet on the change order percentages.
Well, the original change order budget for this project is $4.4 million.
Okay.
And this change in itself is roughly
It's
about
half
6.6.
it's half
So
of
the
that.
4.4 was a 5% contingency.
Yeah.
And so this is adding about 6.6. We haven't spent the 4.4. The 4.4 is still there, but we're increasing it due to this change.
Okay. All right, thank you. Anything further? Commissioner Davis has made a motion that we adopt agenda item number 4, but you have some information that Ryan's going to send you.
Follow up with that.
Okay.
Yes.
Seconded by Commissioner. Yeah, well, we can trust him. Seconded by Commissioners Cabello and Garcia. Any objection? Without objection, we'll adopt agenda item number 4. Thank you, sir.
Thank you.
Any issue sending number 4 forthwith? We'll send number 4 forthwith. Agenda item number 5 is a contract award. Wilshire Area System Sewer Rehabilitation Council District 10, recommending that the board declare M&R Construction the first low bidder to be non-responsive as discussed in the report. Secondly, declare Spinello Infrastructure West Spinello the second low bidder to be the lowest responsible bidder, and award Spinello a contract for the project for $6,102,915. And third, authorize myself or 2 members of the board to execute the contract after approval as to form has been obtained from the city attorney. Mr. Jensen, you are here, and a representative from Spinello is here. That's the card that we did have. If we have any questions, go ahead, sir.
All right, good morning. Brad Jensen with Wastewater Conveyance Engineering Division, Bureau of Engineering. This project will rehabilitate 2,445 feet of 54-inch, 42-inch, 39-inch, and 36-inch pipe. It'll also be replacing and adding new maintenance holes for future operation and maintenance. The bids for this project were received on December 5th, 2018. We received 6 bids for the contract. MNR was the lowest bidder at $5.3 million. Spinello had a bid of $6.1 million. They were 37.68% above our city engineer's estimate. However, based upon the range of bids submitted and the review of those bids, staff believes that these bids are reasonable. This project
In fact, the estimate was off, Brad.
Yes.
Yeah.
Yeah. Based upon some of the looking at some of the elements that need to be constructed, we were low on our estimates. The project included a local business preference program. MNR and Spinello were both certified local business enterprises. It also included a business inclusion program. MNR, the first low bidder, failed to pass their business inclusion outreach evaluation by not utilizing LA Bavin to complete their online summary sheet. Therefore, staff is recommending that they're deemed non-responsive. John Pattison is here if there's any questions regarding that. Spinello, on their business inclusion, pledged 8.33% MBE, 0.98% WBE, 24.38% SBE, 16.05% EBE, and 9.95% OBE. Spinello also pledged 35.37% MSM. Spinello Infrastructure has worked on a number of contracts with the Bureau issued by the Board of Public Works, and there's been no unresolved problems or an inspection, contract compliance, or otherwise. This project does include a project labor agreement. And so in view of these findings, staff does recommend that the board declare MNR to be non-responsive and declare Spinello, the second low bidder, to be the lowest responsible bidder and award Spinello a contract for this project.
Thank you, Mr. Jensen. John? Without going through everything that's in the board report, but MNR, they've bid on lots of our projects. They know what they're doing. Was there any pushback at all from them, or is this something that they likely are walking away from?
Good morning, John Pattison with the Bureau of Contract Administration. After we receive the bids, we typically send a courtesy email to all of the bidders, letting them know that they've used the BAVIN to do their outreach. Now they need to complete their online BIP summary sheet, again using the BAVIN. We did do that on this project, so we did outreach to MNR, Spinello, all of the bidders. A couple of days after bids were submitted, they have until 4:30 p.m. the following business day after bids are submitted to complete their online summary sheet. We noted that MNR had not done that, so on the Friday we did reach out to them via email. We sent them a letter and an email saying, hey, we noticed that you did not complete your online summary sheet. You are non-responsive as per the requirements of the Business Inclusion Program. We did not hear anything back from them. MNR have performed work on previous jobs. They've done the BIP outreach. They've since done a BIP outreach and completed their BIP summary sheet on other projects. Since this project was out to bid, we do not know why they did not complete their BIP outreach summary sheet this time around. They did not do that. They're non-responsive for failing to meet the requirements of the BIP outreach program. Does that answer your question, sir?
Yes. Thank you. Any questions?
Yeah,
Commissioner Davis.
The timeline in terms of this project, what do we anticipate is the time in which we'd like to see implementation of this?
This project, following award, the contractor will be submitting various paperwork before the contract and notice of proceed are issued. I believe this project has a total of 410 calendar days to complete the project.
Okay, great.
So a little over,
Thank you.
about 14 months.
Yeah, that's what I was looking to see. And also, not that we don't expect it, but this is certainly good staff work on this particular project. I mean, obviously, this is what we do. This is what we get paid to do, and we have done it. So with that, Mr. President, I would move we accept this motion.
Okay, thank you. I'll second it. Any objection? Without objection, we'll adopt agenda item number 5. Thank you all. Any issue sending number 5 forthwith? We will send number 5 forthwith. Agenda item number 9 is a report back on the right-of-way encroachments and permitting process motion from Engineering and Streets LA. Ramsey Sawaya, I know you're presenting for both. Let me see if I can just lay the groundwork a little bit, Mr. Sawaya. Yes. So this was a motion that the board submitted, I don't know, 30 or 40 days ago, maybe roughly. And I know that some work is being done in the mayor's office, some work is being done in various council offices, and with your two respective agencies. So we really just asked for an oral report to put on the record the fact that we know that we aren't that we're not going to hit the 30-day request, but we don't want this to go ignored either. So we just thought we would ask for an oral status. So there you are. Let me know if I missed any of that.
All right. Ramzi Sawaya with Bureau of Engineering. Encroachment requests are not limited to one or two types, but rather a wide variety of elements that depending on the area or the community. Just to give you an example, like downtown area, the most typical encroachment requests we get are planters, fences, pavers, etc. But if you move to hillside, it becomes more into retaining walls, stairs, even structures. So what we have done so far, we went back and we have identified all these elements of encroachments, and we have established a criteria, preliminary criteria and guidelines for the revocable permit process to ensure compliance with city and state regulations. BSS as well, they have provided us with their preliminary recommendations. We passed this information along to the working group, and it's been a little bit tough because the working group consists of many offices. So we have identified all the representatives, and the mayor office has helped us out to coordinate and set the first meeting, which is scheduled for April 23rd. So starting April 23rd, we're going to just be receiving comments and feedback from all the representatives, from the city attorney, everybody, council offices, other departments. So at this time, I am comfortable to say that hopefully we can have the policy, all the guidelines and criteria presented to the board in 90 days.
Okay, thank you, Mr. Sawaya. Mr. Rivera, would you like to add anything for street services at all? Okay, great, thank you. Any questions? All right, thank you. I know that ongoing discussions are happening because there was a recent motion filed at the council level that was fairly recent anyway. So thank you, Mr. Sawaya, for the update. The oral report will be received. That takes us to, we're clear on everything but number 3, correct?
That is correct.
Okay. Agenda item number 3, we'll recall number 3. Hearing on ordinance number 184966, termination of NASCO Petroleum LLC, a pipeline franchise. First, find that ordinance 184966 related to NASCO Petroleum LLC for operations of pipeline vault assets below the city's streets expired by its own terms on March 16, 2019. Secondly, concur with the automatic termination of NASCO's ordinance number 184966. Third, order NASCO to cease use of all franchise assets immediately upon action by the board, recognizing the termination of ordinance number 184966. 4, order NASCO to submit a pipeline abandonment plan for approval to the Petroleum Administrator within 30 calendar days in compliance with Section 4.7 of Ordinance Number 184966. 5th, order NASCO to implement all aspects of the pipeline abandonment plan upon approval of the plan by the board. I said 6th, that was 5th. 6, order the Petroleum Administrator to report the status of the abandonment to the Board of Public Works within 120 days of order by the board. And 7th, request the Board of Public Works Executive Officer to provide written notification to NASCO of the board's action. I will note for the record that we have 2 speaker cards representing NASCO Petroleum as well. Mr. Entuck, we will start with you. Tanea from our city attorney's office is here as well. Go ahead.
Good morning again, Uduak Joe Entuck, Patrol Administrator, City of LA. This item is recognition of a pipeline franchise agreement that has expired and terminated. This is a 2.88 miles, 6-inch crude oil pipeline that runs from CD 14 to CD 1 and over into CD 8 is the final termination of it. There's been non-payment for 3 years in 2017, 2018, and now 2019. The franchise, this was the 1-year, 9-month extension. We did do the 9-month extension here at the board last year. It expired on March 16th. There was a notice letter sent by the executive officer to NASCO on the 29th of March, noticing them that automatic termination, according to Section 6.2A of the franchise, non-payment is grounds for termination and automatic termination, and that we could have automatically terminated in 2017, 2018, and now, because it's expired, it's automatically terminated. So today's hearing is a recognition of that status. Both city, state, and federal records show this pipeline is owned by NASCO. The back amount due right now is $68,948. We previously had a hearing in October where we had probably about 15 different pipeline franchise operators who were non-compliant with their bond and insurance. They were issued a penalty at that time of $20,000, one penalty for non-compliance with insurance, one penalty for non-compliance with bonds. That $20,000 in penalties have been paid. They still are not compliant on both, and we have issued second notices of violation. We have a tentative hearing August 5th that will come back here for a penalties hearing for a second round, which would be $25,000 for each penalty, or a total of $50,000 in additional penalties. In the last month, since this, from April, we've gotten some updates. So they did submit an updated insurance information to the CAO's risk manager's office, but it has not been approved or certificate ID number issued.
When was it submitted?
April 4th.
Yesterday.
Let's see. Yes, we checked yesterday.
Okay, so it may take them a little while to review that, but go ahead.
Right. And in our preliminary review of it, it doesn't meet the current standards. It could
Cursory
be
review, it's got a
amended
problem.
before the hearing, but they'll continue to have due process. We did also get a bond on record for $50,000, which is also going through review and could be resolved before the hearing, but we have to continue with the notice to stay on the timeline as required by the franchise. This pipeline is designated as a high-risk pipeline because it transports hazardous material, crude oil in particular. This is a designation by the State Fire Marshal. This pipeline has leaked in the past in 2011 and 2018. Since the leaks, the State Fire Marshal has idled the well. It's not been in operation. It's not used by any oil field operator in the city. It's currently idled with a corrosion inhibitor. We've talked about it before, of pickling the line, where it's basically static in place with chemicals in the water to keep it from corroding, but it's not active. It's been inspected by a State Fire Marshal the last 2 years, but this also does not inhibit NASCO from continuing to operate at the drill site in downtown LA, which is just south of the Public Works building off of 14th and Broadway. They have an active oil and gas site. They use another pipeline through another franchisee, Crimson Pipeline, who is current in all of their requirements, so they can continue to have access as far as a sales point for the site. And so the 7 recommendations are going forward, administratively recognizing the termination and beginning the abandonment procedures, which is the abandonment procedures are outlined in section 4.7 of the franchise. And then I do have one amendment to minor clerical errors in the amendment to the report, and I'll give a written copy to the executive officer. Page 3, paragraph 2, under additional issues, we had the hearing date wrong from October. It was October 26, 2018. Also, second amendment is page 4, paragraph 3, should be amended to board of consideration by the board on April 5th, 2019. The date changed from the time we submitted the report until
the other one's just a typo.
So just clarification. So
okay.
I'm open to take any questions and.
Any questions before we hear from representatives from NASCO? Commissioner Cabello?
Thank you, President James. Just curious, the other franchisee that they're able to work through or with, whatever the right proposition is, Crimson, I think you said, have they had encountered any leaks, or are there been any inspections or any issues like this pipeline we're discussing?
Not that I'm aware of, but I've also not investigated. I'd have to check the records and inquire, but I'm not aware of any leaks or compliance issues with.
Okay, thank you. Anything further? Okay, I understand, Mr. Hollander, you would like to go first?
Thank you. Garrick Hollander with the Cruchot on behalf of NASCO Petroleum. So there are legal grounds, in particular preemption, as well as equitable grounds, why I think this should be denied or at a minimum continued. And I want to give for all of you.
And just so you know, sir, when you talk about preemption, not everybody on the board is a litigator, and not all people listening are litigators. So just keep that in mind as you go through.
Thank you very much.
Be helpful for you. Yeah.
This is definitely outside my arena, so I apologize and appreciate your patience. So preemption is where federal law trumps state or city law. So I'm going to give a little background of what was involved and how this transaction evolved in this incident to give a little color. So for years, this oil well was owned by another entity, person who, from what we could tell, did not necessarily keep it up. Now we have learned, not necessarily operated it in a way to maximize employment or revenues for the city and the company. In 2018, my client purchased it. My client consists of several people and entities, local groups as well as overseas. So it attracted money overseas, which is, I think, good for the city as well as the state and country. And they started cleaning things up. And one of the things that they've realized and continue to realize is that they didn't have all the information and didn't get all the documents. And we still have issues with the former seller with respect to turning over certain critical information. So it's been a battle.
So I'm sorry to interrupt you, Mr. Hollander. Never my intent, really, but only just to try and be helpful.
Sure.
Is the reason you've had, is the exhibit that we have here, the order awarding sanctions in the bankruptcy matter in bankruptcy court, which is not an insignificant amount, is that due to the problems that you've had with the previous owner? Or
Not directly,
okay,
no.
Then go ahead. I was jumping ahead. Go ahead.
Yeah, no, that's okay. This is really complex, and I'm doing my best to simplify
Understood.
it. And if you have any questions, and I'll try not to repeat myself. So my client bought it from the prior owner, again, and started cleaning things up, started paying a debt that hadn't been done, et cetera, and started making it really a well-run machine, if you will. Then two of the individuals who turned my client onto this deal, who were a very, very minority interest holder. It turned out the court determined it was 0.4%, okay? And that was an owner of an entity that owned an entity. In any event, they decided that they wanted to control the company. So they filed a statement of information with the Secretary of State saying they control the company. Then they filed a bankruptcy saying, one guy says, I own 50%, Derek Lamarck, and the other guy, Marshall Goldberg, I own 50%. Collectively, they own 100% of the debtor. That's what they signed under penalty of perjury and filed the bankruptcy petition. At the first day hearings, their lawyer gets up, says, I'm counsel for NASCO. I get up, I say, I'm counsel for NASCO. The judge says, he starts laughing. He says, sounds like the appointment of a trustee. We need a trustee to come in here and take over, because two people say they own the same company. And so what happened is the trustee was appointed, and the trustee had control. In a bankruptcy, a trustee has complete control over the assets and administration of the estate. And particularly since they were claiming that we did bad things and we claimed they did bad things, the trustee said, I don't want to hear from you guys. You can't be involved in this. You can't talk to anybody. So it made it a very difficult challenge, because my client was the one who's running the business. These two other guys were not in the operations. They had the knowledge, but they weren't allowed to share it with the trustee. And so the trustee was working with what she had, and the trustee didn't have all the information because the prior seller didn't give all the information. So it made it very challenging. And in fact, I met with Mr. Nuck this morning and found out about this hearing, this $20,000 penalty. And I said, what happened about that? Why? They didn't know about the hearing? The trustee was not aware of the hearing? And I'm not saying the city didn't give notice, but the person in charge of the company did not get notice. There was a lot of sabotaging going on with Mr. Goldberg and Lamarck, the ones who filed the bankruptcy. They were calling the city, different departments, saying the debtor's doing this, doing that. It was very obstreperous. And so the bottom line is they didn't know there was a hearing. Then they get a bill for $20,000 and they paid it. I said, why didn't you pay? Apparently there's a fee. Why didn't you pay that? Well, I didn't know anything about that. So the bottom line is my client had no control over it, no knowledge of it, no ability to do anything about it. We want to try to do things. There was issues with bonds. Again, they weren't aware of things. They're moving forward. They have a bond. They placed a bond. It hasn't been formally approved. They're making progress.
Can I ask you a couple of questions on what's the status of the ownership now? And I'm going to ask our team about whether or not there are open lines of communication at this point, because clearly, from what you're telling us, there's a lot of moving parts, as you indicated. It's kind of complicated. For us, we don't have the type of legal briefings in front of us that you would have if you were presenting in court, thank goodness. But that said, we still need to try and figure out the right step forward today. So
sure.
Where are you on this ownership dispute now and undertaking to meet the city's requirements at this point?
So in February of 2019, I believe it was February 2019, the court entered an order that determined the ownership, resolved the ownership issues. And that's where I said the court made a ruling. They own 0.4%. Okay. My client owns the balance, and they have no control whatsoever.
So now it's been determined that your client does have the control, so your client does have the responsibilities now and the liabilities that we're dealing with.
Yeah, but let me finish.
Okay.
So first the court had to make that ruling, but the trustee was still in control. And the court also made a ruling that is presented to you, the sanctions order, where the judge issued a sanctions order, joint and several liability, which means everyone's liable for the full amount for the two individuals that filed the bankruptcy and the lawyer. They're all liable for $421,000. There's another order that they're liable for additional amounts. We don't even get into that. The court also entered another order in February that basically will dismiss the case and relieve the trustee of her duties, thereby putting the vesting control back into the debtor, my client, because the court's determination of ownership still didn't give my debtor, the client, control because the trustee was in control. But now, as of mid to end of February, I don't remember the exact date, my client, the case is out of bankruptcy, and my client is in control.
So, Mr. Hollander, is it your intent to dispute what the city contends or is required here, or is it your intent to maybe ask for more time to comply?
Well, I would say, in effect, ask more time to comply. And let me just give you a little bit more from a legal standpoint, getting to the preemption concept. So there is something called the automatic stay in bankruptcy, and everyone is stayed from taking any action to collect. And
it means they cannot take any action. Yeah.
Excuse me?
They cannot take any action. Right.
Correct. And here was this hearing without relief from the automatic stay, and there also was a payment on account of a pre-petition debt. I'm not sure what it was for. I know what the bill says, but it's still not clear. And the point is...
So you think any action under this hearing might actually be stayed by the federal court?
I think the action where the ruling was entered was stayed by the bankruptcy court, number one. Number two, I also think that there's section 108 of the bankruptcy code, is a tolling of the statute of limitations. It basically says if you have something that's going to expire, then it's extended during your bankruptcy. So we were in bankruptcy, it's extended, but yet it wasn't extended. But if this order is entered, the debtor would not have gotten the benefit of Section 108, which is federal law. And so my client absolutely is doing things to comply, wants to make payments, and wants to work with the city. So that gets back to the equitable argument. So there's a legal, I think from
I hear you.
Okay.
Okay. I think I know where we are. Commissioner Cabell?
Thank you, President James. Mr. Hollander, this is, you'll have to forgive me for my lack of legal education. However, this does sound vaguely familiar. It sounds like a telenovela that I've watched recently. That being said, if I understand this correctly, there was forgive me if I'm using the wrong legal terms, determination by a judge that your client is the proper owner in late February. Is that correct?
Correct.
Okay, that being said, why was it then that the $50,000 bond and the insurance not submitted until very recently?
I'm sorry, why was it not what?
So so according to Mr. Entuk, there was a $50,000 bond that was required. That was recently, it's been submitted for review. And yesterday, not any time before, but yesterday, the insurance, the updated insurance was sent to our city administrative officer. Having been determined the rightful owner in late February, why is it that that was submitted so late?
Well, all I could say is they're doing a lot of things to clean up. Your issue, the city's issue, is not the only item that was unattended to or not addressed because of the bankruptcy and because of prior Sellers Act. So they have been doing that. I can't give you, if Mr. Yonay perhaps could, can't tell you exactly why everything wasn't done, but everything can't be done day one when they resurrect control.
No, but if several notices are being sent and you know that if your bill is coming up, you know you have to pay it, otherwise you're going to incur late fees, you're going to pay your bill, or at least pay it with the late fees. So I would say I understand the complicated nature of this business and of the legal matters involved in it, but I think that is something for my colleagues and I to consider, that he was given the rightful ownership, and that's his argument, that there was a lot of confusion and back and forth by minority stakeholders. And this was in late February, and I get how complicated the petroleum industry must be, but nonetheless, they waited until this was noticed to submit the proper insurance and forms. So it's something for us to consider.
Thank you. I would be concerned that there might have, the argument might be made that there was some sort of legal preclusion from taking various actions. I would argue that this wasn't one of them, but the argument could have been made that it was. I don't know. Commissioner Garcia?
Yes, thank you, President James. I have a quick question. During your conversation right now, you said something that there was a payment made of $20,000. Can you elaborate on that? Payment to who? About what? What is the $20,000 for?
So there was, and I saw yesterday, an invoice from the city that said it was a $20,000 invoice it resulted, as I understand it, from the hearing that took place during the bankruptcy, which wasn't attended because it wasn't, the trustee didn't know about it. We didn't know about it. We couldn't have attended anyway.
So was there a payment made?
I'm sorry?
So was there a payment made?
There was a payment. So what happened was the trustee got that bill, so $20,000 from the city, and they were concerned about it because I don't know if there was an email saying we're going to shut you down. I don't know what, but there was a panic. Oh, we got to comply with requirements of the city. Let's pay it. And so they paid it. And when I spoke to Trustees Council an hour, 30 minutes ago, and I said, well, were you aware of the franchise agreement? Because apparently there's some payment there. And she says, no, the only bill I saw was $20,000, and so we paid it. I don't know anything about that.
So the $20,000 was not for the franchise agreement, right?
Well,
Uruguay? No? We don't know.
Actually, if under Ninth Circuit and anywhere in the country, actions taken in violation of the automatic stay are void. And so I would argue that, and could file pleadings to this effect, but I'm just getting into this. I'm just aware of this recently. But the hearing that took place was a violation of the automatic stay. The $20,000 judgment, if you will, that was awarded that day was in violation of the automatic stay. So a payment that was made that day was really on account of the franchise agreement, not on account of any sanctions or what have you. So it's an argument. the city would say, well, that was the payment for what was stated in the invoice. I would argue that invoice arose from a debt that was invalid because it resulted from an action that was in violation of the automatic stay.
Okay, so let me just get this straight. Did your client's company make a $20,000 payment, and to who?
The trustee made a $20,000 payment, presumably the city of Los Angeles, whatever the invoice said. I'm sure it's the city of Los Angeles, but I don't know. I mean, I can
We
find
don't know
that
what
out.
department. You don't know what
I have no
department
idea. I have no idea.
$20,000 went into from your client, and your client doesn't know,
Well,
or the trustee. The trustee is the one that made the $20,000.
Well, she may know. I just didn't ask that question.
Okay.
To be honest, fair.
Okay, thank you.
Thank you, Mr. Hollander. So could I hear from our team? We've got our city attorney here as well as our petroleum administrator. Thank you, Mr. Hollander. Don't go far.
Did you?
In a moment, but we have some questions for our team. So is it possible that we have an entity that's involved in significant ownership disputes that is trying to right the ship, and we just need some more time to allow them to work out their internal ownership issues, and you've seen an intent by them to try and become compliant with everything and catch up, or is your office's experience, Mr. Intuck, more of frustration and not knowing who to speak with and all of that? And then I have the question for our city attorney's office. Is there any possible legal preclusion, even if it's federal court, that preempts us from being able to rule on this today, such that we ought to put it over for some period of time? So those two questions, first with our petroleum administrator, secondly with our city attorney.
Well, one, yes, I would express frustration. Today's arguments are new arguments. We've communicated dozens of times with NASCO through written, email, phone calls. We've had several meetings. We met this morning. The payment, one of the things that we did when we changed from DOT to Public Works, invoices are not done in Excel sheets or randomly issued. They are in the financial FMS digital system. They're only accepted when they're matched to the invoice that was created. The $20,000, which is two separate invoices for the two $10,000 penalties, are unique and were credited from the payments that were sent in. We wouldn't accept a check if we had nowhere to credit it in the FMS system. So to say that those payments were for franchise fees, I think is a farce, and it's a new argument that I've never heard until today.
You thought those payments were for?
I know those payments to be for the penalties.
Got it.
Not for the franchise fee. The franchise-free non-payment started before this bankruptcy proceeding. My understanding, this is something that began in August of 2018, and it was resolved now in February of 2019. They made the payments. The notice issue of not knowing about the hearing or the hearing being invalid is a new argument. We publicly notice all of our meetings. We sent copies of the hearing notice, a special additional letter to the communication on file. When we met with the staff member, Heidi Moe actually confirmed she's gotten all of our invoices. She's got all of our notices. She was aware if there's an internal communication problem. We have never seen any proof of a gag order that there was some restriction. We've heard the claim verbally, but any documentation that's shared to us, we're unaware why.
Well, we weren't presented with one today either. We were presented with a sanctions notice. Okay.
So it's just new information, and it doesn't match with what we've been discussing.
Thank you. Go ahead.
Thank you,
Our
President
city
James.
attorney. Go ahead.
Deputy City Attorney Tania Isagari. Unfortunately, my office only learned about this bankruptcy issue yesterday afternoon. So as to the preclusion issue, I would need to, that's not my area of expertise. I would need to consult with our bankruptcy attorneys, yes.
Okay. Commissioner Cabello and then Commissioner Davis.
Just really quickly, thank you, Commissioner Davis. I just want to piggyback on that. Maybe, Mr. Entek, you can clarify in franchise pipeline ordinances or any kind of agreement that a petroleum company or gas company that makes with the city, what are the provisions in terms of ownership or ownership disputes, or are there any?
We do not have any provisions under ownership disputes. This ordinance was issued to NASCO Petroleum LLC. They represent or have always purported themselves to be NASCO Petroleum LLC. I have not heard from any other owners, but there's nothing in here that says, there is, if there's an ownership change, I think actually they're supposed to notify us.
We'll do what we did with, I believe, item number 2 earlier. And so that we would have to have been notified by whether it's the trustee or this gentleman here who now claims to have ownership. We would have to be notified by somebody in order to acknowledge that they are the rightful owner.
Correct.
Okay, thank you.
One other thing I just add of coming into compliance, the remaining items to come into compliance is payment of the past due fees, having a bond on record, and insurance. All those provisions carry forward even in the termination. So the new franchises had protections to make sure the city, even as we go through the abandonment process, in order to comply, those are the 3 things that still need to happen
to make sure the city's protected.
And we have the hearing on April 5th to address compliance the next time.
You mean
sorry, not April 5th.
You mean the August? What do you?
No, I'm wrong. We have a hearing coming up. We haven't set to the agenda. Yeah, sorry. There's a tentative hearing date. I'm getting today's date.
We have had a couple of these change of ownership type hearings that they have brought to us that we have approved, including agenda item number 2 today, but we've had a couple in prior days as well that would, I think Commissioner Cabello's right, that would indicate just by deductive reasoning that that's part of our process. Commissioner Davis.
In looking at this issue, there are lots of questions. It has been presented that the question around ownership is one that, according to federal law, I think of what I've heard, that once you engage in these kinds of disputes, that federal law compels us to do a stay of not imposing our fee or penalty at that point in time. I don't know.
Maybe, maybe not, but go ahead.
Yeah, but that's a question.
Yes.
So my comments are around questions. So that is a question. As it relates to our awareness about the bankruptcy deliberations that we did not know. And thirdly, our city attorney has not had an opportunity to appropriately process the information presented to the legal representation for the city so that we can get a response from our own team in terms of some of the statements that have been made around federal law. Certainly in many cases, federal law is the preeminent law. But again, we have to be able to process that. So I guess my comments then, given the questions that I have, is around this point in time, what is it most appropriate for us to consider as it relates to this case? Obviously, we want to make sure that we have the right process and procedures about understanding this problem. Doesn't appear to me that we have enough information to clarify right now, or no one here in the room that can clarify for us some of these concerns and questions that I have raised legally. So having said that, it appears to me that in terms of public policy, that perhaps at the very least, we might need to continue this until such time that we can get more definite, concrete answers rooted in the rule of law in terms of what it is that we should do, given the fact of not having anybody to address what has been proposed to us as what federal law compels us to do when there is a discussion around ownership, and that the imposition of fees from local government during that period of time is or is not something that should move forward. We don't know. We have nobody here to tell us. And so I am saying that we need to consider extending this particular case until such time that we can get all of the cards on deck.
Okay, thank you, Commissioner Davis. Here's what I would, well, just following in commentary and of my colleagues, and then we'll continue along with the resolution for today. But I agree with you partially, but only, and Tanea, this is really a question for you more than Uduak. I tend to agree. I think Commissioner Cabello's questions provided enough of a foundation for us to move forward today in granting the order requested by our Petroleum Administration Office. However, if your office, I want to give your office the opportunity to take more time if you think that this bankruptcy ownership issue could affect, and stay issue that Commissioner Davis references, could affect our ability to move forward. And if that's okay, I mean, if that's something that your office would like, I have no problem with that. We can put it over, but we would, I don't want to put it over very long, because I do think, and even Mr. Hollander hasn't made, when I asked him, didn't say that well, we're not actually obligated to do these things. But so that's really my question is, the only thing I would think is an issue at this point is whether or not your office wants a little bit more time just to determine what, because you just found out about the bankruptcy yesterday, as to whether or not that bankruptcy affects our ability to take this action.
I believe that would be the best course of action. Like I said, this just came to our attention yesterday. I believe the first payment that they missed was in 2017, and I don't even know when the bankruptcy action began. So I would recommend and request that our office be given more time to evaluate this.
Okay, Commissioner Cabello?
Yeah, thank you, President James. Colleagues, I would just say this. There is plenty of time for, at the very least, if not to actually pay the fines, because they are hefty fines, but to notify the petroleum officer of the change of ownership, to make sure that, hey, I'm back, I'm the guy, there was a dispute, there was some confusion, there's some clarification. And I understand the legal issue, the stay order, what have you, but I find that NASCO is not performing in good faith. So I would actually, and I'm okay with the motion going to move this forward. There's no second, I'm fine with that too, but I do not believe they've acted in good faith.
Well,
okay. And we do have a speaker card that by the Brown Act, I do need to cover before we take a vote. But go ahead, Commissioner Davis.
The issue of their accountability is an issue that we probably need to know the answer to, but it does not alleviate us from compelling to follow federal law. Now, having said that, I would like to know in terms of, and where's the burden of proof for notification of federal law? Is it with them, or where is that burden of responsibility with the action of the federal court? But what I would like to know is, from them personally, do you feel that we should have been made aware in terms of your action earlier, as far as your involvement in federal court, as your responsibility to us with the fees that we have been pursuing? Should there have been some feedback from you at some degree or another?
Your question is for Mr. Hollander.
Yes.
Mr. Hollander, go ahead.
I'll first, and it's only fair that you see a brief, quite frankly, from us as well as the city. But to answer your question, and this was a unique situation, it was the guys who didn't know about the business, Derek Lamarck and Marshall Goldberg, that filed the bankruptcy. They're the ones who listed the schedules of creditors, which gave rise to the notice that was given. So to be honest, I don't know what the schedules say. Maybe you weren't on that. And then NASCO never had control. So you had these two guys who filed the bankruptcy, who listed people, and then the trustee took control, trying to figure out what's up and what's down. And so it is conceivable that there was an actual notice from the standpoint of the service list. But there was notice at some point that there was certainly constructive notice, number one. And number two, As far as whether you're noticed or not, I believe, I'll double check this, but I believe we couldn't seek sanctions against you. If you didn't have notice, we couldn't seek sanctions for violating the automatic stay, but that wouldn't negate the fact that any actions taken in violation of the automatic stay are void, whether you have
That's
notice
correct.
of it or not.
That is correct, and I understand that. So basically, I just wanted to know from you that you did not contact us, and
We had no, I didn't do anything, and my client didn't do anything because we couldn't. That I could assure you of. We had no control, we had no rights to do anything. The trustee had complete control over notification. And I can't tell you right now whether she gave you notice.
But didn't you, I'm sorry, sir, didn't you have the ability after February 2019 to do this?
At the time, yeah, after February, the debtor had time. But at that point, the bankruptcy had been dismissed, so it's not notifying you of a bankruptcy. So just to be clear.
Can I ask just one clarifying question?
Let me make sure Commissioner Davis is done, and then we'll go to others.
They did not contact us, and I wish they had contacted us to let us know. However, at the same time, their failure to contact us does not alleviate us from our responsibility from the action taken by federal court. And that would be my concern, and I don't know if the city attorney agrees with that, but that is probably a concern that I have, that whatever their failure is doesn't necessarily in any way alleviate us from what our responsibility is. But I just wanted to say to you, I definitely feel you should have contacted us, but we have another burden past you, but I just wanted to get that on the record.
And if I could just say just one high-level thing, may I?
20 seconds.
20 seconds.
Now I'm putting time on you because
Okay.
we're repeating ourselves. Go ahead.
I had a conversation earlier today about all the homeless out there. We're trying to do the right thing. We have employees. We want to keep this company alive. And we'll make the payments. We're getting the bonds. We're doing everything. So I think we need to look, forget the technicality. Let's save jobs and let's make.
It is what it is, not a problem.
Thank you.
Thank you. Commissioner Garcia?
I just have a clarifying question. So since February that you know now that you're the property owner, have you submitted a change of ownership to us since then?
I would have to defer.
Well, can I get a direct answer? I just want a yes or no. Have you submitted?
I have not personally.
Well, not you. The company. Has your client?
Can we? I don't know.
Yes, he can come forward.
Yes, he can speak and give a direct answer.
Hi, my name's Amit Yonai. I own 25% of NASCO. We bought it in 2018. To answer your question, the seller, who was delinquent on basically everything that he ever had. I mean, we came into this thing with delinquencies on everything. He is refusing because his bond, we replaced his Dogger and City of Los Angeles bonds, but they haven't released him from one of the bonds yet, and therefore he's holding us kind of hostage and not letting us transfer the title to the company. So this is another issue that we have with the seller. It's really unbelievable. But I just want to say regarding this, we immediately went and got the bond. This was filed in mid-March, so this wasn't filed yesterday. So I have a thing that was filed mid-March. The original bond was sent, and then we're working on the insurance, getting all the general liability and everything else done, and we want to make payments to the city.
Okay, Commissioner Garcia?
I'm
You still have
good.
the floor.
I'm good. Fine.
Okay. So we have some more questions. I'm sorry. Mr. Yonay?
Yeah.
And I want you also have your opportunity to speak. I know we're asking you questions. I don't want to take your opportunity to speak away. But did we just hear you say your argument is you have 25% ownership?
Yeah.
Okay. Because we're concerned about where the other 75% is that we're dealing with today. And that might be a question for our city attorney and for our petroleum administrator. But why don't you, Commissioner, do you have a question for him before he tells us what he wanted to tell us?
No, just for the record, I actually want to, given in light of this new information where we're not negotiating here with a a majority stakeholder in a company, I'm withdrawing my motion to move this forward because this is even more confusing, because I think what the argument Mr. Hollander was making is trust. Trust us, we'll get this done, we want jobs. That's great, yeah, so do we. But the problem is we don't know who we're talking to, and it's trust but verify. And it's not so much about what this sanctions order is, it's more about who are we negotiating with and do we legally have that responsibility. So what I would ask the city attorney to do is please help us clarify and understand what the basis of us being able to terminate this pipeline franchise ordinance is, and with whom, like who's the other side that we're terminating with. This is, I appreciate the difficult position you're in, sir. I appreciate the complicated nature of this in terms of ownership, of trustees, of sanctions orders, and learning new legal terms every day. That's great, but I don't think we have all the information at hand. I don't think we know who we're sitting with on the other side of the table, who we're terminating with, what that legal entity is. And once we determine once that legal entity is, I will be very comfortable with voting in favor of terminating this pipeline.
I agree,
And so I withdraw my motion.
I agree with you on that, and I believe that we have to work with our city attorney to get the answers and moving forward, and that's where I'm at.
Okay, thank you all. I agree with you both, but I've got to give Mr. Yone an opportunity to speak. You get a sense of where we are.
Sure.
We've given you that.
Sure.
And then I may have just a couple of follow-up final questions for our city attorney and our petroleum administrator. Go ahead,
So
sir.
the other 75% are two partners of mine who are international investors. They're not here physically, but we control, we own practically 100%
Well,
together.
that's helpful. We may have our petroleum administrator, though, and our city attorney work with you to bring all of the interest before us before we make a determination one way or the other, because you said you had 25%. Now you're telling us the others are partners.
But I'm officially also the manager of the business.
I'm sorry?
I'm also officially the manager of the business.
Oh,
so.
Okay. Okay.
I mean,
Okay.
whatever you guys need for me to prove it to you or whatever, we'll do
Okay,
it.
so we'll have you work directly with our team on the questions that they have. Anything else, sir? We don't have any further questions
Yeah,
for you.
I'd
Anything
like
else?
to
Go
also
ahead.
say, I had a meeting with Mr. Natak, and I believe Daniela was in the meeting? No, the previous meeting. I don't remember the date, but we did sit down right after the judgment, so we actually got control back, and we did notify and talk about the whole bankruptcy situation, how crazy this whole situation was. I worked diligently to get the bond in place. The bond is in place. I signed it personally. We're working through the insurance. By the way, a bond is not 1 second. It doesn't take 1 minute. You got to go through the whole
And
process.
we know that. We have bonding issues we deal with contracting.
Right, so it's not like, you're talking about mid-February.
Or yesterday.
You're talking about mid-February to mid-March is a reasonable time frame where you actually got the bond. So, I mean, I think we're making very good progress. I would like to pay the city. I would like to pay the petroleum administrator for all the previous years, etc. But again, the last hearing, like you guys heard in October, we weren't here. We couldn't be here. So
Okay.
I hope we can start something new and give us a chance. And if it doesn't, you'll see that we're not what we're saying. We're not doing it. Then you have all the right, obviously, to terminate it. But we would like to have that option.
Okay. Thank you, sir. Udawakan Tanea from our team. How much time would you like for, and we, look, one thing that is great about these hearings, we have now a representative who's said that have access to 100% of the ownership, standing here telling us they want to catch up with what was owed in the back prior years with this asset. So at least we have that. We didn't have that necessarily before. But that said, all that we're interested in from our city attorney's office is how much time you would like to have for your office to work on the legal issues for us to reset this hearing, which, by the way, sir, Mr. Yone, that's your time window to get square with Mr. Intuck's office, okay? Because you've heard where we are on this. Yeah, go ahead.
I would ask for a minimum of 2 weeks, but we can work with whatever your board decides is a reasonable amount of time. Again, I have to consult with our bankruptcy attorney about all of this. I expect there'd be a lot of requests for documentation, especially in terms of ownership. So at least 2 weeks.
Okay. Commissioner Cabello.
Thank you. For the record, I think maybe an out on the 19th, but we want to find a date that...
I was going to say, how about the 24th?
Yeah, I'm fine with giving time. I think that I would add to that not just the legal issues, but also to figure out a way for both the city attorney and the petroleum officer to verify ownership, to verify that we are actually able to negotiate instead of someone up here saying, I'm the owner, trust me, I'm in control. We need to figure out a way that we know that we will not have this problem again. I'm sure you are absolutely honest, sir, but I want that legally verified in some way, shape, or form. And also for the record, and please, Mr. Intuck, correct me if I'm wrong, fees will continue to be incurred during this time. Is that correct? Okay. I just want that for the record.
Accumulate until August, late fees on this year's.
Good point. Thank you, Commissioner Cabello. Okay, so the 24th looks like a day that works for, I want a 5-member commission. So let's make sure that everybody's here. I'm available on the 24th, Commissioner Cabello. You are? Commissioner Closa? 24th. Dr. Campos, we have availability on that day. Oh, Mr. Intuck?
If we do continue the item, I just would like to add on a request that the pipeline maintain idle status until we resolve. Because right now it's idle. It's been idle for several years.
Well, yes, that would
maintain its idle status until it's resolved.
That would be in order to maintain current status. Does this maintain current status?
It's currently, that's its current status.
Okay, that's all.
Idle with corrosion, chemicals, and not in use.
Right. We would. So that would be our order regarding this continuance. Dr. Campos, are we okay on the 24th?
Yes, that would be a Wednesday. Yes.
Okay. And your office as well, everybody is square on the 24th? Mr., you have availability? Okay, great. Thank you. Then that's a little more than 2 weeks, about 2.5 weeks. All right, so thank you. And gentlemen, you're both available on April 24th? Okay. You can. At your own peril, but go ahead.
I don't know the process. Am I allowed to submit a pleading?
Yes.
Okay.
Yes, you can submit anything you want.
And is there, what deadline do I have and who do I send it to?
We would like it at least a week ahead of time.
Okay.
And submit it to Dr. Campos, and he will give you his card and his information.
Thank you, sir.
All right. Thank you. And you can submit it online as well. I mean, you can email it to him. That's fine. Thank you, Mr. Hollander. Yeah, and we don't have the pagination and the margin requirements. It can be in letter form, whatever's easier for you, all right, that the court's put on you. All right, thank you. So, yeah, thank you, sir. Thank you, everybody. Hopefully we'll get to the bottom. Well, we will get to the bottom of this. Thank you, everybody, up here as well. That's what's so great about our board. Dr. Campos, we're clear of the desk?
Yes, you have.
Then we are adjourned. Thank you, everyone. Have a nice weekend.